Welcome, everyone. My name is Jarrell Agatep. I'm the current and also next year's FBANC Social Code Director. I'm a privacy associate at Baker Hostetler with my practice emphasizing CCPA, GDPR, and employee workplace privacy. Speaking of which, what Mari said, this meeting is being recorded, and although we're only recording the speaker's view, if you do not consent to the recording, please feel free to turn off your video and audio. Before we get started, FBANC want to thank the Dolan Law Firm and Farella, Braun, and Martel for their continued support of FBANC and for being our Pamana Legacy sponsor, our top sponsors for this year. And we are excited to launch our FBANC Member Spotlight Series called Bayanihan. The term Bayanihan means being in a bayan, which refers to the spirit of communal unity. FBANC's goal is to feature members and spotlighting their practice areas to provide practical tips and advice to our members. To kick off our Bayanihan series, our featured FBANC member today will be discussing importance of estate planning, which has been really highlighted by the recent COVID-19 pandemic. But before introducing her, I would like to remind folks about our upcoming events. We have a virtual clinic this upcoming May 17 to 23, and Mara's going to put the links to the events on the chat. We're hosting a visual legal clinic with the Justice and Diversity Center of the Bar Association of San Francisco in May 17 to 23. We are still seeking volunteer attorneys with expertise in the areas of workers' rights, housing, employment, unemployment, family law. If you're able and available to be part of that, please reach out to our FBANC Clinic Director, Lynette Bucklig. We greatly appreciate your time and support of our legal clinics. Our next event would be another member spotlight featuring Javelle Lamano next month, May 20. She's the founder and principal of Lamano Law Office. Javelle will discuss how to increase cash flow conversion rates and what systems you can put in place to sustain a small law firm during a global pandemic. Please register as soon as possible. And last but not the least, we are having our 41st installation gala ceremony in June 3rd. We will be awarding close to 30,000 scholarship grants to law students and aspiring law students, and we greatly appreciate your attendance. By the way, this meeting may qualify for MCLE credits, and to get more information, Mara is going to drop our FBANC Professional Development Co-Director's email, Natalie Garcia Lashinsky's email to request for credits. All right, without further ado, it's my pleasure and honor to introduce our first FBANC Bayanihan member spotlight, Nicole Ramos Takemoto, Special Counsel at Candeleria PC. Nicole leads Candeleria's estate planning and trust administration group. Her experience includes preparing all types of estate planning documents for a diverse range of clients, as well as handling complex trust administration and probate matters. Nicole has a particular interest in counseling clients regarding separate property and community property issues, business succession planning, and California real property taxes. Her services also include conservatorships, guardianships, and adoptions. Prior to joining Candeleria firm, Nicole was an attorney at a prominent trust and estate law firm in Orinda, California. There, she assisted high net worth clients with family wealth preservation, advised married clients with substantial separate property assets, and helped clients meet their charitable giving objectives. Nicole obtained her JD from Golden Gate University School of Law, where she was a merit scholarship recipient. She also obtained an LLM in taxation with honors from Golden Gate University. These advanced degrees allows Nicole to design and implement sophisticated estate planning techniques and to effectively identify and minimize gift, estate, and property tax issues. We will have the opportunity for question and answers during the last 10 minutes of this meeting, but please feel free to write down your questions in our chat box. All right, please give a virtual round of applause for Nicole. And here she is, Nicole Takemoto.
Thank you. Thank you, Cheryl, for the introduction. I will share my screen. I have forms to share and also an outline. So let me set this up. Let's see. And then, okay, share. Okay, so we have a lot of ground to cover and not a lot of time, so I'll try to get through this, but definitely contact me afterwards if you have questions regarding the forms I'm sharing today, because I don't think I can get through every possible question in the time we have. So let me see if I can start this. Okay, I will just summarize and not go through the slides to make it quicker, but basically an estate plan is setting yourself up with documents to allow for agents to act for you if you become incapacitated and to distribute your assets after your death. And part of why everyone needs an estate plan right now, even the most basic plan, is because of COVID. And sometimes, you know, there's a hospitalization and you need to help your parents pay their bills or access their bank accounts and also sign forms on their behalf. So for, you know, and for everyone that this could happen, especially now, it doesn't matter what your age is or how healthy you are with COVID, you know, it's shown us how serious illness can happen quickly to anyone. And that's why I'm going to show you 3 documents that you can prepare for yourselves to at least put a basic safety net in place. And we will start, okay, this is the incapacity. I'll go straight to the forms. Okay, so these are the forms. I'll also send around the PowerPoint so you can read the information that we skipped. But these are the forms we will go through today, and we'll send them out in PDF version by email to the attendees. And I'll also attempt to drop them in the chat. So power of attorney. Let me see if I can figure out how to, I don't know. Okay, the statutory durable power of attorney. Let me minimize. Do you see it on my screen? I think so. Okay, so the difference is statutory forms, the language for these forms are in the California probate code, and it's this exact language. So it's easy to make a valid document if you're doing the statutory form because we know that this works. Personally, I also draft the attorney drafted forms. So these are completely custom language. They're usually a little bit longer. And, you know, it's appropriate in some situations when people have specific instructions that they want to leave for their agents, or they want to limit the power of the durable power of attorney. But for the most part, the statutory forms for power of attorney and healthcare directive are cover pretty much every situation for most people. So we will go through this. A power of attorney is only effective while you're alive. And so at death, the power of attorney is extinguished. And the purpose of this document is just to have someone act on your behalf in financial and legal matters if you are incapacitated. So there's 2 types of powers of attorney. There's effective immediately and then springing. This form that we're looking at now is effective immediately upon signing, which means the agent you designate here can take this form to the bank or to a loan officer and start signing things already. Usually that's what we advise, to have one that's effective immediately, because the alternative is a springing power of attorney, and that is effective only upon incapacity. So incapacity is determined in the document, and it's usually a certificate signed by a physician who has examined the principal and, you know, declares that person incapacitated. That a lot of people choose that because they feel that it's a safer choice because there's not this effective power of attorney, you know, in the file somewhere that someone can use. But it does add a little bit of a time delay because you have to find, you know, contact the physician, have them schedule an examination. And, you know, based on the calendar, we don't know how long that could take. And what I do recommend is if you are choosing the agent that you really trust, you should feel comfortable giving them an immediately effective document. If you are uncomfortable giving them this document, then they might not be the best choice to be your agent here. So sometimes it's a spouse, a child, and that's not like a blanket rule, but generally, if you feel comfortable, you should also feel comfortable making this immediately effective. So when you receive this power of attorney in PDF format, it's pretty self-explanatory and it's really straightforward. So this top part is you just put your name and address, and then here is the powers. And these are the default powers in the California Probate Code. So if you look at the instructions, you can choose option N, all of the powers listed above, or only initial certain things. For example, it's really common for someone to only do real property transactions because maybe they're a co-owner of a property with someone and they want that person to handle a sale. So they would not grant the rest of the powers, but they would do real property only. So depending on your situation, you might need to limit it. But for general incapacity planning, you'd want to give all of the powers listed above, because if something happens,
Nicole, I think you froze a little bit there.
Yeah.
There you are. Okay, you're back.
I think I'm back. Hopefully we're okay. All right, so that is here. Here, it's possible for you to put in special instructions. So here again, what I see commonly is limiting it to a certain transaction. Maybe there's a real property sale or a contract that needs to be signed. You can delegate that authority to your agent and then write that here. So that way it's more of a special power of attorney. When it's limited to certain things, it's called special. When it's broad, it's general. Here, this is saying that this power of attorney is effective immediately and will continue until it's revoked. So if you feel strongly about having a springing power of attorney that is effective only upon incapacity, you would write that here in special instructions. This power of attorney is not effective until, a physician certifies that I'm incapacitated, something like that. And if you have questions about language to put here, I can help you with that. And so this is saying this is a durable power of attorney. So you're creating it now while you have capacity. At a later time, let's say, in 3 years, you become incapacitated. That's saying that this does not invalidate this document. And so that's why it's called a durable power of attorney, because you must have capacity to create it and sign it. And then when you become incapacitated, it still survives. And then we have this, and this doesn't make sense if you don't want this power of attorney to continue if you become incapacitated. It's kind of the point to have, but again, sometimes you just want to delegate someone to help you in a particular transaction. So in a real property sale, it's like, I want to have my sister take care of all the paperwork, but if something happens to me, then someone else, that delegation goes away. So sometimes that does make sense. You can put at the top, it says an agent. Let's see. Okay, here is where you would put the name of the person you delegate. You can put, one person, or you can put 2 or 3. And here is where if you want them to act together or in succession. So if they're to act unanimously, let's say you put two names, they act unanimously, they have to be present for all transactions. Well, not present, but they have to sign off on everything. So writing a check, signing a contract, everything that requires action, both have to do it together. So it's a little bit complicated sometimes to have 2 agents at the same time. I would put if you feel comfortable, maybe 1, 2, and 3, and then in this line say that the agents are to act in succession. So that way your number 1 agent is really the one who's acting, but if that person is unable to, then you can go to number 2 and 3 as alternates. And it's definitely good to have an alternate here versus just leaving 1 agent at the top and then no alternates. If something happens to your agent or they can't do it for whatever reason, then you'd have to do a whole new document. So at least think of 1 person to be an alternate. And then here is an explanation a little bit about how to do separately or jointly. And then this is pretty much it. This is where you sign and date. You would sign this in front of a notary. So you should fill out the top part until we get to here, and then, have any notary public witness your signature and then fill out this part, and then they would do the acknowledgement here. So that's required to have this document be valid. You need to have your signature notarized. I will take, should I take any questions now or wait till the end? Let me see. I think I will just,
Actually, we have one question, Nicole, in the chat, and I could ask it. It's actually from Mari. Her question is, does this work in the whole state of California? For example, her parents lives in Reno. So is this a uniform form for anywhere in the US?
Yes, so this is our California form, and other states have adopted the same language. So this would be for a California resident. And like a California resident signs this and notarizes it here, but then it can be used, in other states.
Outer states.
Yeah, so I can take it to Nevada and my agent can sign things for me in Nevada. So what I would do for an out-of-state parent or an out-of-state sibling, these are forms usually available for free in like law libraries and other types of public places like that. So you could locate, a Nevada statutory form power of attorney and have them fill it out with a notary in their state. But yes, if a California resident does this here, it can be used in other states.
Great. Another question, Nicole. This is from Leo. Do you typically recommend spouses to have power of attorneys for each other?
Yes, definitely. I think for the most part, spouses, they have joint bank accounts, they're on mortgages as co-borrowers. So in a lot of circumstances, they can already do these actions and help each other. But there are other things where they wouldn't be together, like life insurance policies or retirement accounts. If you have a power of attorney and you and your spouse have one over each other, you can help with financial institutions like that. That's one common thing, life insurance and retirement accounts, because those are usually the spouses are not on there together.
That makes sense. Thanks, Nicole.
Okay. I think I will move on. Let me see to the next thing. Okay, the Advanced Healthcare Directive. So it's similar to a power of attorney, but this is only for medical decisions. So the power of attorney form we just saw, that's for financial and legal transactions. This is for medical. So it's consent to treatment or let's say, what is it called? Like life support and things like that, and receiving confidential medical information, because that is very protected. And usually hospitals and healthcare providers won't disclose much to your spouse or to your child unless they have a written authorization from you. So the Advanced Healthcare Directive also helps with that, just allowing your healthcare provider to share information. And so let me pull up what it looks like. Okay, here is the Advanced Healthcare Directive form. There's a long explanation at the beginning, which is self-explanatory, and then we get to the fill in the blank type of things. So here is where you would designate an agent. And this again is for healthcare decisions only. You would put them, and you would put as much contact information as you feel comfortable, because if this is on file in a hospital, they'd want to know, how do we contact your medical agent. Home phone and work phone is good to have at the least. Address is not as important, but it's still really helpful. So you would have your number one agent here, and then you have the options to do alternates. And so here again, I do recommend to only have one agent designated to act versus co-agents, because it causes delay and a lot of confusion. So I would just put a second and maybe a third alternate here. So that is where you would put that in. And there's a lot of this form that is optional. So if we look here, you can read this here. The agent can make all healthcare decisions, but you can limit it by writing language here. So sometimes a person does not want to be taken off life support under any circumstances. You could say something like that here. And yeah, if there's certain treatments that you would not consent to yourself, if you had capacity, you would leave those instructions here for your agent. Okay, and then similar to the power of attorney, there's a springing healthcare directive or immediately effective. And I think particularly for the healthcare directive, it should be this one where it takes effect immediately. And the reason is, like, in practical terms, if a doctor is able to communicate with the patient themselves, and the patient is lucid and understands what the questions are, the doctor will 100% of the time follow the instructions of the patient, using their judgment at the time. Sometimes there's a question about capacity. Maybe somebody is, in and out of consciousness or a little bit disoriented, but is not going to be permanently incapacitated. If you have this effective immediately, whoever's with you, your spouse or your child, whoever your agent is, can already start helping the doctor with, medical decisions. And I think it's because capacity is not always black and white. That's why it's really helpful to have this effective immediately. And you can also feel comfortable that the doctor will follow, their priority is to follow the patient's instructions. If they feel that the patient understands, is giving consent, that they understand what is going on. So that I recommend effective immediately. Let's see if we have this. Okay, so these are optional. This is, if you want, you can create a list of instructions to attach to this form about healthcare decisions, let's say choosing a nursing home or things like that. You could create an attachment. That's not required, but it's possible. And if you leave this form pretty broad, your agent has the obligation to act according to your best interest and to what they think you would want. So when you're choosing your medical agent, you should choose someone that you communicate with, that would understand, what you would want and feel comfortable doing it. A lot of times children wouldn't want to do what their parents say, for whatever emotional reasons. So choose an agent that really aligns with what you would want, and then give them the broad authority to make the decisions rather than limiting it, because that actually adds more confusion, because there are a lot of facts that can come up that we will never anticipate. So if you just leave it to the judgment of your medical agent, that's really helpful. Here, if you want to make organ donation or direct the disposition of your remains, you could write that here or attach additional sheets. So if you leave it broad, then it's up to the agent's discretion. So an agent could authorize organ donation, and the agent will decide what to do with your remains. people who have, you know, specific disposition requests for their remains, they would attach sheets here to give instructions. But if you leave it blank, that's okay, and you're leaving it up to your agent. This is nomination of conservator. So that's one thing we should talk about. One reason that somebody needs an estate plan is to avoid the burden and expense of a conservatorship. So that is when an adult doesn't have the capacity to take care of themselves. And so there's the conservatorship of the estate, which is only financial, and conservatorship of the person, which includes these medical decisions. So, you know, let's say somebody is totally fine, and then in their advanced years, they develop dementia and they really can't continue with their banking or, you know, understand what medical consents that they need to give. If you don't have a document in place, then a family member would have to go to the court and file a petition for conservatorship and have somebody appointed by court order to be able to make these decisions for you. And that takes a while. It's based on the court's calendar, although there's emergency procedures if that's really necessary. So it takes long and it's also expensive. It's the attorney's fees to prepare this petition and file it, and all of that stuff is really a lot, and it can be avoided very easily by having at least a power of attorney and a healthcare directive. So, you know, for yourselves, you should do this, and also think about your parents to at least get a power of attorney and a healthcare directive. They may be far from needing it, but it's good to have in the file. You won't need a conservatorship if this is done correctly. Here, this is instructions for healthcare. So some people leave this blank. This is kind of like the life support provisions. If you feel strongly either way, you can check the box A or B, or you can leave it blank and it's up to your agent. And so this is, you know, some people have very strong opinions, so they'll do that here. And then that's similar here. This is called palliative care, relief from pain. Sometimes certain treatments that they give you for pain relief kind of have the effect of, you know, making you go downhill in other areas, but you want the pain relief no matter what it does. And that's what it says here. You direct treatment, even if it hastens your death. You can leave it blank and it's up to your agent, but if that's something you want, you would specify that here. And then this part is really broad, also optional, if you have any other instructions to leave to your agent. This is organ donation. Some people do not want to do organ donation at all, so you would line this out if you don't want to do that, or you can make a selection or leave it blank. This one is to notify your agent who your primary physician is. This is something they should know, but you know, maybe they don't live locally and they don't know who your primary care doctor is. You could put that in here if you wanted to. And then here again is the signature part. And so this is different than a power of attorney. And the way it's different is because you can, to make it valid, you can sign it in front of two disinterested witnesses, and then it's valid without a notary. So sometimes that's the case in when you're in the hospital, or it's like a medical emergency. Two disinterested witnesses. So it cannot be an employee of the hospital or the healthcare facility, and it can't be somebody that's named in the document. So if you name your son as your agent, he cannot also be a witness. If you have a friend visiting you, or you know, somebody else, those persons can be a witness. So you can decide if you want to have it witnessed, or you can have it notarized. And I think the page, so the page is not attached. I will make sure that the one that we distribute, the PDF, has the notary page. You can, instead of that, sign this in front of a notary and have them stamp it, and that makes it valid. So it's either or. You can have 2 witnesses or you can have a notary. You don't have to have all of those things. And then this is just a special requirement for people that are in a skilled nursing facility, because you'd have to have a patient advocate witness this also. And I think it's to protect, vulnerable populations in a skilled nursing facility. It's easy to have financial elder abuse, so they want to make sure there's protections in there. So that's why there's this requirement here. And are there any questions for this? This is something I recommend you at least you have in your file, and then give a copy to your primary care doctor. And I will move on to the statutory will, because we're going to run out of time. So the statutory will, this is a pre-printed form, and the language is in the California Probate Code. You have to sign it and date it in front of witnesses, and they can't benefit from your will or estate in any way. So they can't be a family member. They can't be a beneficiary named in the will. Let's say you're leaving a cash gift to your friend or some, personal items. You cannot have that person be a witness. The executor you nominate cannot be a witness, and the will should not be notarized. In some states, you can notarize a will, and that makes the will effective. You don't need witnesses, but here in California, you need 2 disinterested witnesses, and that's the only thing you can do. So there's no need to have it notarized. A lot of people assume that just having 1 notary stamp and that 1 notary witnessing is enough, but that isn't. In California, we don't notarize wills at all. And so let me pull up the form. Okay. So the disclaimer I have to give about the statutory will, it will, nominate a person to distribute your assets. It will nominate someone to be the guardian of your minor children if they are to need a legal guardian. But having a will alone will not allow your estate to avoid probate. So probate is a court supervised administration of one's estate. And so you would file a petition for probate, and then a judge would supervise the process every step of the way. You would file an inventory of the estate assets. You would file, an accounting of all the transactions going on in the estate. And then there are no distributions from the estate without a court order. So it's restrictive because it freezes everything, and makes delays if you need to sell a house or give an allowance to your kids for their support. You can't do that without a court order. So the will is good to have, but you'll still need a probate unless you have other planning documents in place. And so in California, that is why living trusts are so popular. Living trust is also known as a revocable trust. And this is the trust that you create during your lifetime, and it takes the place of the will. So it will describe who your beneficiaries are and what assets they will receive. And then you retitle your assets into the trust. So if you own real property, you would have it deeded into the trust. If you have bank accounts and investments, you would have that retitled in the name of your trust. And that is how Californians avoid probate. So at death, you'll have a successor trustee in the document, and that person will take inventory of your assets, follow the instructions for distributions, and then close the estate. So there's no need for any kind of court supervision or public filings. This is it's faster, and it's more streamlined, and it's less expensive. With probate, you have to pay fees to the executor and to the attorney. So there's like 2 sets of fees, and it's calculated based on the value of your assets. So it's not based on, the time that the person actually works, and it's also based on the gross value of your assets. So if you have a house that's $500,000 and you have a loan of $300,000, the $500,000 is what's used to calculate the probate fee. So it's not, it's gross value of the estate. So this is the statutory will. And this one in particular, it's important not to alter it in any way. You can't, cross things out or add language to expand it here. You just have to limit your handwriting to whatever blank spaces are, have a boundary. So here, it's pretty self-explanatory too. You would print your full name, and then it goes through sections that are optional. So this is gift of personal residence. You can leave this blank, or you can give it to one specific person. So here it says, only if you want to give your house to someone different than the balance of your estate. Usually people don't do that. They have their whole estate be one unit, and then they divide it in percentages that way. But every now and then you'll say, maybe you want to give your house to a child and then your other assets to your other child. So here you can specify just the gift of your residence. And then this is gifts of tangible personal property. So when you're filling this out, pay attention to what you're giving away. So this one is for your residence. Make sure you go through it slowly. This is for tangible personal property. So this is everything that is not financial assets. So actual physical objects like furniture and jewelry and things like that. That's what you are designating here. So there are options. You can give it all to your spouse, or not to your spouse, but instead to your kids, and then or to different people. So this is just personal property. It's easy, people will usually give it to the spouse first and then the children second. But if you have specific gifts, you could write that in. Because let's see, that would go here. Okay. Now this is cash. So we've dealt with the residence, we've dealt with the tangible items. This is gifts of cash. So if you want to make any charitable contributions or give a gift to a family member or friend, you would just list them one by one here and the amount of the cash gift. So that is pretty self-explanatory, and some people, they don't have specific gifts, so they would leave this whole thing blank. And then here, number 5, pay attention to the title, is the balance of the estate. So this would be for your investments, your checking account, your savings, stocks that you have, everything else that is not, a physical item. And then for real property other than your personal residence. So if you have investment real estate or vacation homes, that will be included here in the balance of your assets. And then here you would carefully read the instructions and choose one choice only. And I'll give you the opportunity to take a look at that. And here you will note that if you don't sign any box, if you complete this incorrectly, the court will distribute your assets as if you didn't have a will. And if you don't have a will, the California Probate Code sets forth who receives your assets at your death. These are your legal heirs. So I'll kind of summarize that now, because a lot of people do die without a will. So the first people who would get your, like in general, your spouse would be your first legal heir. If you are unmarried or, don't have a spouse, then if you have children, they're your legal heirs. So spouse number 1, then children. If you have no spouse or no children, it goes up to your ancestors. So they see if you have living parents. If you have living parents, they will inherit your whole estate. If you have no living parents, you go down a generation and your siblings will equally split your estate. And then if your siblings are deceased, but you have living nieces and nephews, then they will split your estate. So there is a place for your assets to go if you don't do a will, but a lot of times that won't work for everyone. The default rules won't work for everyone. Maybe there's estranged relatives and they don't want them to automatically inherit, and that could happen. Or, you know, you want to provide not equally, you want to provide more for somebody who needs more, and someone who's comfortable provide less for them. So that's why it's important to have a will, because at least you can get out of the default rules in the California probate code. Okay, and this number 6 is for guardianship of your minor children. If one parent dies and there's another living parent, that person remains legal guardian. But if there's no other living parent and the court needs to appoint a legal guardian, here is where you would put your nominees. And the court always appoints a guardian, and listing your nomination here is not always automatic. It's given, you know, due consideration, but at the end of the day, the judge will appoint the person that's the most appropriate or act in the best interests of the child. But you definitely want to have a nomination here, because that says a lot, and it also helps your family members with decision makings. They'll know between, you know, who you wanted versus talking between themselves and deciding who to pick. You can make the decision. So you would have your first, second, and third choice here. Okay, and this is for assets passing to minors. So this will be for your children. If your children are minors at the time of your death, someone will be the custodian of their assets until they reach the age of majority, which is 18. But here you can extend it up to 25. So sometimes the person who will have the physical care of your children will also have the care of their assets. Sometimes people separate that and they have a different person be in charge of the child's assets, and then another person, you know, take custody of the child. It's up to you to whether or not to do that. So that is what you would put here. Who takes care of your minor children's assets? The problem, not necessarily the problem, but when you do this versus a trust, as soon as your child reaches 18 or whatever age you select up to age 25, then the assets are transferred to them and then they have complete control. So you can't create in this statutory will an ongoing trust for your kids. A lot of times, if you have minor kids, you want a trustee to manage their assets until an older age, maybe age 30. Or, you know, sometimes parents set up a trust for lifetime if they want a trustee to always be involved in the management of assets. Here, you don't get to, you completely relinquish control once the child is old enough to have ownership of these assets. And the reason it goes to age 25 is the California law, Uniform Transfers to Minors Act. The default is 18. So if you don't specify otherwise, when your child reaches age 18, all assets are transferred to their name, but you can make it 19, 20, up to 25 here. But you can't, for example, say age 35. That would not be valid. When they reach 25, they would have to receive their assets. Okay, and then here is where you would nominate an executor. So the executor is the person in charge of following the instructions in your will. They will file the will with the court and collect your assets and participate in the probate process, and then eventually make the distribution. So here you would do your first, second, and third choice. Here is whether or not you want your executor to have a bond. So a bond is kind of like an insurance policy against an executor's, you know, bad acts. If you would have to find a bonding company and then pay for a bond, which costs like a few $1,000s. And if your, you know, your named executor embezzles the funds and then leaves the country, a bond is like an insurance policy that covers the losses. But usually it's an additional expense, and a lot of times the person you nominate is someone that you trust. So I have not seen a will where the person wanted a bond. Everyone generally waives bond. If you die without a will, then whoever probates your estate will have to get bond. The default is that it would be required. Okay, here you sign the will in the presence of 2 adult witnesses, also disinterested witnesses. So they can't be anyone who could be a legal heir. So no one in your line of descendants, no one in your line of ancestors, and it can't be anyone who's a beneficiary of the will. So if you're leaving something to friends, they can't be a witness. No one that can possibly benefit from your will can be one of the witnesses. So what you would do is, you don't sign this unless the witnesses are in front of you watching you sign. And this is what the required from the witnesses must read this before signing, because this is what they're attesting to. I will kind of scroll through it, and then we have the witnesses to sign here. And so witnesses sign in print, and then a residence address is really important. Sometimes there's a will contest or some other reason why we need to track down a witness, and that happens. Maybe a child is saying there was undue influence, or the person who did this will didn't have capacity at the time. We would find this witness to testify as to whether the testator had capacity. So definitely a residence address is important, and at least 2 witnesses, not 1, and then not notarization. So I think we have 12 minutes. That was fast, and there's a lot of things that I couldn't get through. So I will circulate the PowerPoint slides, circulate the PDFs of these forms, and then I'll be available for questions as you're going through this. But let me see, I can put my that's if you need a power of attorney. Okay, well, let's see. Here is my, okay, is that showing phone and email address? Okay, so I can take questions now, but when you get the forms, definitely ask me, because there's a lot of, things that I might not have gotten to in this.
Great.
Yeah.
Just couple of questions in the chat, Nicole. One, first one, does having 2 disinterested witness but also notarizing the will makes it invalid, or
it will not? That won't make it invalid.
Okay. And then another one from Monica, do in-laws count as family members?
I think they do.
Okay.
I mean, technically they wouldn't under the probate code because they're not like a blood relative, but there can be an argument made that, they could have unduly influenced the testator. So I would really choose someone with no personal relationship in that way.
It's more of like if they get challenged.
Yeah, to be safe, I would not do in-laws.
Got it. And then another question, would you recommend putting together a will over a living trust?
Usually not. And the reason, again, is to avoid probate. I wouldn't recommend a will over a living trust, but I would recommend a will versus not having anything at all.
Yep. Mm-hmm.
But for probate, there is a threshold. So if the value of your estate is lower than, it's $166,000 and then $166,250. That's the threshold for a probate. So let's say your estate is $100,000. There's a quick way to get that distributed to your heirs without probate. But anyone who owns real estate probably has more than that and should have a living trust. So I don't know if that answered the question, but I would not choose a will over a trust. I would choose a trust over a will.
Got it.
Sorry, just quick follow up on that. Is it gross? Like you're talking about the house and the debt.
It is gross. Correct.
It's gross. Thank
Yes.
you.
So even if the equity is lower than this threshold, it still would have to go through probate.
Thanks, Nicole. Another question, do you recommend the executor to be an attorney?
Not necessarily. A lot of people choose a friend or family member that they trust with, the paperwork. It's a lot of work. It's a lot of hours and a lot of forms and a lot of phone calls. So it doesn't have to be an attorney, but it should be someone that's organized and that will pay attention to detail and will do a good job of it. So it doesn't have to be an attorney. Some people don't have someone that they trust with paperwork in their families, so they want to hire a professional to be the executor. And so that's a private professional fiduciary. So that would be appropriate if, let's say your kids don't get along and you just want a completely neutral person to administer your estate. That's one reason people hire a professional. Or, your kids are in college, like everyone's busy and no one could really devote the time to doing a good detailed job of administering your estate. Then you could just nominate a private professional fiduciary in your will. But most of the time I've seen the spouse first and then adult children and then maybe other family members.
Got it. Another one, are the rules a little bit relaxed during COVID and signing of disinterested witness over Zoom?
Not that I know of. So that's a good question. And I don't know of any like emergency rules that would make it okay to be over Zoom. I think I don't want to recommend that anyone try because it could be challenged. It's easy to have someone, in front of the video signing a will, but you don't know who else is in the room with them to influence them to sign this will or anything like that. So it really opens up
challenges.
Yeah, for challenges.
So, and just follow-up question on that. Can you sign it by DocuSign, or that's also
okay? It has to be
in person. Yes,
a handwritten signature. And then that includes the witnesses, also handwriting.
Got it. Do we have any other questions from our members? I have a question. So what do you normally say to like our parents, our tatais, lolos that really doesn't really take their time planning their estate? Because it's a little bit of like taboo talking about like, oh, I'm dying and all that. And I think my parents doesn't even have a will, right? So what do you say to those Filipino members of our community?
Sure, that's a really good question, because a lot of times talking about death is taboo, or talking about your parents' personal assets is also taboo. I would at least start kind of broaching the subject with a power of attorney and a healthcare directive. And it's easier to say, I want to be able to help you if you get sick or if something happens. So it would be really good if we could talk about this power of attorney and healthcare directive, because otherwise, if you get sick, I won't be able to, help you pay your bills or sign things on your behalf. That's a little bit easier because it's less about asking for anything. You're not trying to plan, what your inheritance is. This is just offering assistance if they get sick, and they're going to want to do that and make it easy for them and for you. As far as doing the will, I mean, I would just ask them if they've thought about it. I wouldn't really say you should create a will. That's a little bit harder, but I would say, have you ever thought about what would happen to your estate when you pass away? Or, so at least that plants the seed and they can think about it, and they probably don't know what happens. Like, this is a time to educate them, and this is a time for me to tell you what to tell them. If you don't have a will, mom and dad, then this is what happens. It'll go to your kids equally, and then things like that go down the line of succession, and that's probably okay with them. But a lot of times there's a family member they want to disinherit, or they want to divide the estate in different fractions, not necessarily equally. And if they seem receptive to having the conversation, that's when I would bring up maybe the idea of a trust and tell them about probate a little bit. Like, I would not open up with that. You kind of just ease your way into it. And if they're like, yeah, I want to make this easy, or I want to think about my documents and do something right now while I can, then you could explain that, you know, if you don't have a trust, your assets go through probate, which means a judge supervises the administration. And there's all these filings with the court. There's an inventory of assets that's also filed. Anything can be looked up, you know, it's public records technically. And so that's why people also try to avoid probate. They don't want a list of their assets filed with the court. And then, you know, at that point, if they're open to it, just explain the very basics of estate planning, and then, you know, invite them to talk to a professional. And as far as, you know, hiring a professional, like if somebody calls me, it has to be the parents themselves. A lot of times kids will call to make appointments for mom and dad. And that's okay if it's a doctor or a dentist. But for me, a lot of times the kids will make the first call, but I won't. I'll say, you know, the mom or dad has to call me, and then I'll put them on the calendar, because it has to be the person themselves. Yes.
And do you, in light of that, do you recommend us telling our parents about holographic will, which is like to start?
I'm thinking, I don't know. I would think that it causes more harm than good. If you tell them that it's possible to do a holographic will, then they're gonna probably say like, okay, it's free, it's fast, I'll just
that's right,
do it by handwriting. But that can cause a lot of problems, like a lot of problems. I would rather have them deal with no will at all than a holographic will.
Got it. We have so many more great questions, Nicole, and this is one from our founder, Ray Ocampo. What is the typical cost of probate in California?
Sure. I think I have a slide for that. So let me see if I can. Okay, the statutory fees with an example. So depending on the law changes, but it's percentages of what it is. So that it's like a sliding scale that increases, and then at the bottom is the example. So a gross probate estate of 1 million would be 26,000, but then it's made twice. So the executor gets $26,000, and then the attorney gets $26,000. So for a total of $46,000 paid from the estate.
So it really depends on the value of your estate.
Correct.
That's gross value.
Gross. So a lot of people have a house that's worth $1 million, but their equity is not that much. They would still have to pay these $46,000 in fees.
Another question here, squeezing them in. Any recommendations when parents have properties in the Philippines?
That's a good question, and a lot of people do. So for estate planning here, estate planners here can do what's like an international will. So there's a will convention where we can just, you know, draft the will in a way that they can bring it to a foreign country, and that foreign country can follow the terms of that. But that's also not something we can guarantee. So if your parents have property in the Philippines, contact an attorney there. Because for one thing, you can't put a non-US property in a trust. So like a condo in the Philippines, you can't put that in a US trust.
Awesome. And last one, are there any notary publics you typically work with, or or Candeleria's office also has?
We have notaries in our office.
Awesome. And any other questions before we close out the meeting from everyone?
I saw that Ray asked he'd be interested in. You see that one?
Yeah. Ray, another question. He's interested in the percentage of those on this call who has wills, trust, or healthcare directive.
Yeah.
I personally
could have made that a poll.
Yeah.
And it's probably not. It might be like no one.
Super low.
Yeah.
Yeah. But again, thank you, Nicole. This has been really informative, personally informative for me, and I'm pretty sure for everyone that has attended this meeting. If anyone has a question for Nicole, Nicole, can you just flash again your contact information?
Yes. Yeah. And so I encourage you to prepare these forms for yourselves and then let me know. I can walk you through it. Mhm.
Thanks, everyone. And last but not least, we encourage everyone who is not a member of FBANC or expired membership to please do renew your membership. And don't forget about our upcoming events, our legal clinic, our next membership spotlight, and our gala in June. Again, thank you, everyone. Thank you so much, Nicole, and great seeing everyone.
Thank you. Thank you for everyone's time.
Bye-bye.